He looked at the material, found it was plainly disproportionate, and said that there had to be a review mechanism. But it was possible to construe, as is often the case, under the powerful interpretative obligation under Section 3 of the UK Human Rights Act that Fiona mentioned, possible to construe the rules compatibly with the Convention. One other case, similar area, H&L against the A City Council. And you'll see all these cases are anonymised, and I'll mention that later under Article 10. It's a 2011 case in the Court of Appeal. Here, a couple, one of whom had child sex conviction and was facing trial for another allegation, and a partner who I think had been accused of something similar but not charged, were found by the council to have concealed in an application to the council in relation to their disability requirements the fact of the conviction. The council examined their factual circumstances behind their backs, so they were involved in disabled persons groups, and decided to notify a wide range of groups of the fact that this man in particular had been convicted in the past and was facing trial for a further offence. And they did that without giving the people notice they were doing it. They only informed them of the fact of notifying all these other bodies after they had done so. And there was no evidence that these two individuals had any contact with children in their work or personally. And the bodies to whom the council supplied the information had nothing to do with children. They were to do with adult bodies only. And the Court of Appeal found this was plainly in violation of their rights, not only under Article 8, but also under the common law. They hadn't been given a fair hearing, they hadn't been told in advance of the action which the council proposed to take. And on both counts, the council found for the individuals, that the court found for the individuals. So a very clear steer there, not only from the Supreme Court, but also the Court of Appeal, in relation to the Article 8 rights of individuals who, in respect of whom, there may well be legitimate measures to protect the public. Moving on to Article 10, I haven't got anything funny to finish on for the Friday, but certainly I try and keep the celebrity, sexy gossip to the very end. The most entertaining aspect of human rights work in English bar is definitely the super injunction work, where you get to find out all the terrible, terrible, outrageous things that go on. You're bursting to tell colleagues and friends. You can't, and you really can't. It's not like everything else where barristers tell each other, all manner of privileged and secret things. In relation to super injunction work, you really can't tell anybody because it will always get back to the news of the world. So, but before we get to the sexy stuff, the serious stuff, and this is a curious case, and one again where I'd be very interested to hear how you think the Irish courts would have dealt with it. It's a case called Guardian against the HM Treasury. It's also known as the Pannick case. It's one of the first cases decided by the Supreme Court in 2010. Very important case because it deals with the question of anonymity. To what extent is it legitimate to anonymise the parties in sensitive cases? And it became very common in English judicial review, in asylum cases and in human rights cases, for people to request anonymity to protect their, they argued, their Article 8 family rights in particular. And the government were quite happy to anonymise things. They didn't really seem to care whether the public knew what was going on or not. Often it's assisted them to anonymise. And the courts became increasingly concerned about this. And this case involved 5 individuals, known as X, K, M, G, and H, who had their assets frozen under one of the most draconian pieces of legislation I've ever seen in respect because of allegations of a connection to the Taliban and Al-Qaeda. Again, I don't know if you know about how this regime works, although it applies in Ireland also. The United Nations have a list of people they have been told by the Americans are suspected of a link with international terrorism. And it really is as simple as that. The Americans present a list to the UN produces almost no scrutiny at all, they publish the list, and the European Union, who rubber stamps it, adopts the same list. All the member states, including Ireland, are required under the relevant regulation to apply the list. There's no judicial scrutiny at all. And similarly, the United Nations have this list, which under English law, under a particular order, the British government will rubber stamp and then apply. So these individuals have their assets frozen, and it's not possible for them to challenge the substance of the allegation in any English court. The English government is simply applying the UN measure, and the English government's position has been consistently to say, if you have a problem, go to the UN. Now, until very recently, there was absolutely no right of recourse in the UN. Now there is a kind of a tribunal where, as far as I'm aware, no one has ever succeeded in overturning these asset freezing measures. It's one of the most unjust, I suppose, results of the war on terror. And it is very widespread. This is a very lengthy list. And all of these individuals had been named. It wasn't open to them to challenge the substance of the allegation, so that had to be taken as a given. And they argued that they wanted their names anonymised because if people found out, they would think they were terrorists, and it would be very difficult for them to carry on their normal lives. The court started by saying, we don't like the fact that everything's anonymised. It's important that people know what's going on.